I'd like to call this meeting of the Urbana Plan Commission to order. Could we have a roll call, please?
Mr. Ash?
Here.
Mr. Fell?
Here.
Mr. Fitch? Mr. Hopkins?
Here.
Mr. Otto?
Here.
Mr. Pollock?
Here.
Ms. Stagg?
Here.
Ms. Tompkins? And Ms. Upa Band.
Okay, we have a quorum. Under changes to the agenda, we're going to go ahead with the agenda the way it sits, but my understanding is that we're going to hear a presentation on the third case tonight, the CCZBA 743-AT13. And then it was staff's recommendation that we send that to a future meeting. There's continuing discussions with the county on that, but we will hear the presentation and then hopefully send that along. Could we have a motion to approve the minutes of March 21st, please? I'm sorry?
Would we be taking, question on the agenda, would we be taking the presentation first then, or would we still be proceeding in the?
No, it'll be in the same order. We just won't be sending a recommendation from this meeting to City Council. It'll wait till June, perhaps, maybe a little longer. We'll see. Okay. Again, approval of the minutes. A motion, please.
So moved.
Mr. Ash, second? Mr. Hopkins. Any changes or comments? If not, those in favor of approval, please signify by saying aye.
Aye.
And opposed? Those minutes are approved. Under communications, we have a couple things, one of which references that county case 743 in front of us, and the other is a letter to the Plan Commission from Howard Wakeland, who had a petition in front of us at our last meeting that was the recommendation was to recommend that City Council vote against this, and before it got to City Council, he withdrew that case, and he wanted the Commission to see his communication on this to the Plan Commission about our handling of that case. Okay. We don't have any continued public hearings. We have no old business. We have no new public hearings, and under new business, we'll start with Champaign County Zoning Board of Appeals 734 AT12. Request by Champaign County Zoning Administrator to amend sections of the Champaign County Zoning Ordinance regarding contractor facilities in County B1 zoning, Rural Trade Center, and B5 Central Business Districts.
All right. Like you introduced, this is a Champaign County ZBA case, text amendment to the county zoning ordinance to allow those contractor facilities in B1 and B5. A little more specifically, the proposed changes, they would amend Table 5-2 of the county ordinance. This would allow contractor facilities with no outdoor storage and no outdoor operations. They would be allowed by right in the B1 district. Currently, they're allowed by right in the B4, B5, I1, and I2 districts, and a special use in the AG1 and AG2 districts. The next change would amend the same table to allow contractor facilities that do have outdoor storage and/or operations, again by right in the B1 district, and it would be a special use in the B5 district in the county. Currently, this use is allowed by right in B4 and I1 and I2, and is a special use in County B4 if it's not properly screened, and it's special use in AG1 and AG2. And then the last part would just add some standard conditions for allowing contractor facilities with outdoor storage. It would spell out standard conditions for those special uses in the B5 district. So why are we reviewing this? Proposed text amendment is of interest to the city to the extent that it impacts our land use and development decisions within the 1.5 mile extraterritorial jurisdiction. The city has subdivision and land development authority in the 1.5 mile ETJ. The county holds zoning authority in this area. So it's important to have consistency between the two jurisdictions, just in case things are ever annexed into the city. We don't want conflicting land uses for things that are in the city with things that are right outside the city adjacent. And these county cases could affect our ability to grow according to the comprehensive plan. So for these reasons, Plan Commission should review the proposed amendment and make a recommendation to City Council whether or not we should form or launch a protest of the proposed amendment. If we do have a protest, an official protest, then it would require a 3/4 supermajority of affirmative votes at the county board for approval, instead of the standard regular majority. So with this case, the issues we're looking at, this is really brought about by 3 requests out in the county with contractors. One of them had purchased some land in the B5 district and didn't realize his operation would not be allowed. The other 2 are contractors who want to add self-storage warehouses to their operations. None of these are in the city's ETJ, just to let you know. So this is basically to remedy those situations, to allow them to have the storage they want. So by state law, we should review the proposed amendments for consistency with our comprehensive plan. Look at a couple goals. Goal 17, minimize incompatible land uses. That's something this text amendment addresses by requiring screening between by requiring screening between contractor facilities with outdoor storage that are next to residential areas. Another goal from our comp plan, Goal 21, identify and address issues created by overlapping jurisdictions within the ETJ. This would definitely do that. So the proposed amendment is generally consistent with our comprehensive plan goals and objectives. In terms of zoning impacts, there would really be none for Urbana. There's no county B1 or B5 districts within our extraterritorial jurisdiction, so it really doesn't have any net effect for us. Contractor facilities are already allowed in County B4 and County Ag 2. Those are the districts that we generally see within our ETJ. And just for comparison to our current zoning ordinance, we allow contractor facilities by right in the B3, B3U, B4, B4E, IN1, and IN2 districts, and as a conditional use in the B1 district. So the proposed amendment is generally compatible with that. Options for Plan Commission. For case CCZBA 734AT12, you may recommend to defeat a resolution of protest, recommend to defeat a resolution of protest contingent upon some specific revisions to the proposed amendment, or recommend to adopt a resolution of protest. And tonight, staff is recommending that you defeat a resolution of protest with no conditions. Just to let you know about scheduling, this is proposed to go to the county board on May 23rd. So we would need to get our resolution of protest or no protest through City Council by May 20th. And I'd be happy to answer any questions for
Which
you.
means that we should decide tonight.
Yes, please.
Any questions for staff? As I was reading this, and this is a little broader question than just this case, I found myself looking at all these various districts within the county and not being exactly sure how they lined up with ours. I'm assuming that the lower B districts are smaller neighborhood business operations, and the higher the number, the more intense the usage. It would be really interesting, and if not a lot of trouble for staff, to be able to have a list of city zoning districts and county zoning districts and see how they compare, which ones that we have in our district compare to which ones that the county has.
Mm-hmm.
So I would ask that if that, guys at your plan meetings think about whether that's something that's easily done. It might be helpful for the commission and the council to be able to compare what they would like to do and its impact on our districts, which are not exactly the same.
Yep. Just a note on that, in our zoning ordinance, we do have a table that kind of matches up. If a property is ever annexed, it lists all of the county zoning districts, and it lists what they would convert to. So that table kind of gives the names of the districts, but maybe not all of the descriptions of the county districts.
I'm thinking of something like that, maybe a little bit more detail, but not a lot.
Mhm.
I'm not talking about a whole full-blown thing, but when I read this, I want to be able to relate it exactly to what our ordinance would say about that,
Mhm.
if you can do that.
We can do that.
Any other questions for staff? Yeah.
I'm a little slow tonight. I thought I understood the first part, but then in the issues and discussion, it says the impetus for this is to correct a situation in a B5 district in Longview where they want to have self-storage to their operations. But I don't see in these changes that are proposed, I mean, where that's allowed.
Yeah, I did kind of gloss over that point. Basically, actually, I don't think that applies in Longview. He doesn't want to have self-storage. He wants to have outdoor storage for his contractor shop. But to the self-storage point, these other two contractors, basically they want to add self-storage as a second principal use, which is how the county would handle that. And those other properties are currently zoned Ag 2 in the county, which does not allow for two principal uses. So the county zoning administrator believes the most efficient way to handle this is to allow the contractor use in B1, which is a rural trade district, and then to rezone those properties to B1. And the B1 district also allows for two principal uses. So they could have their contractor shop in addition to the self-storage on the same property.
And your opinion is that would be a good thing for Urbana if that happened outside of our city limits but within our jurisdiction? That would not conflict with our...
Yeah, I think it would be generally compatible with our set of regulations.
Okay.
Jeff, could you tell us what exactly you mean by when I think of self-storage, I think of the places where people drive in and they rent lockers and such. I'm assuming from the sound of it, this self-storage is actually the contractor's sole use to put their equipment in, or what are they talking about?
No, I think you were right with your first inclination there. It's basically these contractors, they have large property with lots of storage, so they would like to add that self-storage mini warehouse where people run in with their own locks.
So this would basically give them the ability to run two businesses on the same piece of land?
Yes.
Okay. All right. Any other questions? Is anybody representing the petitioner here this evening would like to speak before the Plan Commission? Does anybody else want to address the Plan Commission on this case? Appears not. And if there's no further questions for Mr. Engstrom, let's go ahead and open this up for discussion. Motions? Something?
Okay, so I move that we recommend the recommended council defeat a resolution of protest on ZBA 734 AG 12.
I'll second.
We have a motion and a second. Any discussion? If not, could we have a roll call, please? This is to defeat a resolution of protest, which is our recommendation to the city council that they say this is okay. Just in
Right.
case anybody was wondering. Yes.
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 And that passes, and this will go to our city council on May 26th, did you say?
May 20th.
May 20th, okay. So for all those thousands that are really keyed up about this, they can address the city council on May 20th. Next case, CCZBA 741 AM 13, a request by Marcus Harris to rezone 1414 Triumph Drive from County Light Industrial to County General Business B4 District.
All right. This is our second county ZBA case we're looking at tonight. This one is actually a rezoning instead of a text amendment. We don't get a lot of rezonings. So this is looking at 1414 Triumph Drive. It's a 1.46 acre parcel just outside of the city. If you look at the map here, you can see Triumph Drive comes off of Cunningham Avenue, and it's just half a block north of the city here, 392 feet out of the city. The property was formerly an equipment rental and sales business. It's been vacant as of late. Again, by state law, the city has the authority to review these zoning decisions in our ETJ to make sure they jive with our comprehensive plan and to recommend protest or no protest. A little bit of background. The applicant inquired with Champaign County Planning and Zoning whether or not they could operate a gun sales and indoor firing range on the subject property since it's vacant. The property contains two buildings, both of which have large storage spaces, which would work for firing range. One of the buildings also has some more office space, conditioned space. In Champaign County, gun sales and firing ranges are allowed under the use category sporting goods and sales and service, and that use is not allowed in the county I-1 light industrial district. So the petitioner is proposing to rezone to County B4 general business, in which sporting goods sales and service is allowed. And this location is good for that zoning district because it's pretty close to other properties zoned B4. And we'll get into a little bit here. So properties immediately north and south of the site are currently zoned B4. To the north is Bill Smith Auto Parts. To the east is Peterbilt Truck Sales and Service, which is zoned light industrial. To the west is McCormick Food Equipment. To the south, you've got a wholesale distribution facility, also zoned B4. The petitioner had previously planned on opening gun sales and firing range business within the city of Urbana. However, this location seems to work better for him, so that's why he's pursuing this rezoning. Looking at the county zoning districts, the intent of their B4 general business district is to accommodate a range of commercial uses and is intended for application only adjacent to the urbanized areas of the county. So this site meets that criteria. The I-1 light industry district, the current zoning, it's intended to provide for storage and manufacturing uses, not normally creating a nuisance discernible beyond the property lines. So looking at the City of Urbana Comprehensive Plan future land use map, let me pull this up all the way down here. Here it is. So okay. So here's the future land use map number 1. You can see it's just outside of the city. It's in the future land use designation for this area is light industrial office, although it is just north of regional business, the Pink, in the city. There's also a note here. It says rural agribusiness opportunities along US 45, assist in marketing. So this would be considered a rural business, more appropriate for rural than for urban. Looking at our comprehensive plan goals and objectives, goal 16, ensure that new land uses are compatible with and enhance existing community. The proposed uses would be compatible with the general area there. Minimize incompatible uses, same deal. And goal 21, identify and address issues created by overlapping jurisdictions in the 1.5 mile ETJ. So in summary, staff finds the rezoning would be generally consistent with these goals of the comprehensive plan. Looking at the city zoning, the question to ask is, does the use match the type of uses that would be permitted in the same or similar districts in the city? So looking at that table 4-1, if the property were to come into the city, it would be directly converted to county B4. I'm sorry, it's currently, if it's being proposed to be county B4, which would become city B3 if it were being brought directly in. Given the general commercial nature of this area, the proposed rezoning designation is appropriate. Firearm sales would be allowed in city B3. Firing range is not allowed in city B3. Is allowed in city IN1 or ag or CRE. Another thing we look at is LaSalle National Bank criteria for rezonings. First criteria looks at the existing land uses of the zoning of the nearby properties. It's a mix of sales, service, and distribution uses nearby. They're all generally compatible with general business. The second criteria looks at the extent to which property values are diminished by restrictions of the ordinance. So the proposed rezoning would allow for sale of the property. If the rezoning is denied, the property would remain unused until another use can be found. Just switching this view back to look at the uses around there. Okay, the next two criteria, does the proposed ordinance promote the health, safety, and morals of the public? And would there be a relative gain to the public as compared to hardship imposed on the individual property owner if the rezoning is denied? The current restrictions of the zoning, the I-1 light industry district, they're really designed to promote industrial use and to limit retail use on this site. However, the site is along a major commercial corridor just outside of the city between us and Rantoul. The current zoning doesn't necessarily protect the public welfare at the site, but denying the rezoning would impose a hardship on the owner. The fifth criteria, the suitability of the site for the proposed zoning purpose. Again, the general area is commercial in general. The county is determined the proposed rezoning will help achieve their county land resource management plan goals. And the buildings on the site are suitable for alteration to become retail and firing range use. And the final criteria, the length of the time the property has been vacant. Unfortunately, we are not able to tell that County staff wasn't sure exactly how long it's been vacant. Again, options, forward to council with a recommendation for no protest or to defeat the protest. Option 2, forward to council with a recommendation to defeat a protest contingent on specific provisions. Or the final option, forward to council with a recommendation to adopt a resolution of protest. And city staff's recommendation is to forward to council with a recommendation to defeat a resolution of protest. And I believe the petitioner is here tonight. I'd be happy to answer any questions for you.
Questions? Mistake?
Well, on page 72, could you clarify, please, the red line indicating with an arrow indicates something, but I don't know what it indicates. It's near I-74 and
It's-
Frasca Field.
The red line on the
On
comp plan.
page 72.
Yeah. Yeah, that's in the comprehensive plan, our comp plan.
What?
Libby,
Yes, that red line. Mhm.
I think
Yeah.
that just indicates it's a major arterial connector.
It's just what?
It's a major arterial connector. Is that right, Libby?
It's Cunningham Avenue.
Mm-hmm, yes.
I think it's designating the road.
What?
I believe it's designating the extension of the road.
The extension of it?
Yeah, let me look that up and see if I
Oh.
can.
Uh-huh. Well, I just couldn't
Oh,
see.
you know, it's, I understand it now. I think it's trying to, it goes along with the annotation that says rural agribusiness opportunities along US 45
Yeah.
to show that that's the vision along that portion of 45.
Oh, uh-huh. Uh-huh. Okay. Thank you.
As I understand it, in the county, in County B4, both the sales and firing range are permitted by right. If it converts to City B3, the sales would be okay, but not the firing range. If it converts to City I1, the firing range is okay. What about the sales?
Right, sales are not allowed in I-1, or sales are allowed?
There's one where both are
Yes,
allowed and
yes.
one that only one is allowed. And I can't remember even why we set that forward, because it
Nope.
would have been smarter to keep it both on B4 and
It's-
I1, but I can't remember which it is, Jeff.
I
actually.
remember, it is,
No,
yes.
are we talking, I'm talking about a City
Yes,
I1.
in the city light industry, IN1, both sales and firing range are allowed.
So
That's a
so
special
there
use.
is a city zone that it could be converted to that would not be unreasonable given the amount of I-1 zoning around it, that would leave both uses conforming. Okay,
Yes.
that was my question.
Ordinarily, the way that would be done is through an annexation agreement, I assume.
Yes, that's
Which we're
correct.
not looking at here.
Right. There's no plans to annex.
I'm just,
Mhm.
I'm looking to not create a future problem unnecessarily or unintentionally.
Mhm.
So when this were rezoned as the county proposes and the owners propose here, and it came into the city, and it's pretty close, at some point it would be a non-conforming use.
If it came directly in, yes, but we always have the option of negotiating an annexation agreement.
That
to
would
change it.
include a rezoning so that it
Mhm.
would be conforming.
Yes, yes.
Any other questions?
Well, is it okay? On our future land use map, page 72 at the back, we see that we're close to I-74 and Frasca Field where the subject property is, right? Is that right?
Mhm.
And the land use map shows that there are opportunities along US 45 for marketing. I don't think it's wise to market guns right there. We already have a place for guns on the city. We don't want more guns. We need to stay, I think, industrial. guns do not belong in the area. So, I think, was Mr. Harris the same person who asked for a place inside the city,
Yes,
which
yes.
was granted for a firing range and sales? And I'm very, very much opposed to rezoning
Is there
the
a question
property.
here for our staff?
Well, why wouldn't we stay with why wouldn't we stay with where we are? Why would we go? It seems like we don't need that many guns.
From a staff perspective, it would be a larger lot, more appropriate buildings for the proposed use than the smaller lot that's within the city.
Well, is he going to stop the one in the city, or are you going to take
I
that one
believe
away
so,
from
yes.
him then?
That's a question that you could ask the petitioner. He's here, and he'll speak in a little bit.
He'll come up in a minute.
Any other questions? Mr. Hopkins, it looks like there's something on the tip of your tongue. You good?
No.
Okay. Let's open this up for public input. Would the petitioner care to address the Plan Commission this evening? Welcome back.
Well, thank you. I'd be happy to answer any questions. I don't know if I have a statement. Otherwise, you guys, you've all heard me. And
I think we just had one.
So basically, the question was, why aren't we using the one that we went through the exercise of a gun range and a gun shop in city limits, and we allowed it in an I-1 or a B4, and I had a proposed location, but I have since given up on that location, and I'm using that location just as my own storage, actually, and have given up the other locations due to the fact that the Learman Group and some of the others did not like that area. I moved farther out to the outskirts because I felt it was more conducive. As Jeff said, we found a larger location with a larger parking lot with a more direct route from good access to 74 and 45. And really, when I actually purchased that building, when it was an I-1, I thought, this will work very, very well, because the city of Urbana would actually, in an I-1 district, would work. But instead, I went to John Hall at the county, and he said, well, actually, indoor sports facility under a B4 fits better, and sporting goods retail. And so that's why we're here. And actually, I was going to ask Jeff, on that map that you pulled up on the I-1 and B4, the county has it listed that everything except for the Peterbilt dealership has already been changed to a B4, actually. So I don't know which one's right. I'm not claiming that you're wrong. I'm just saying that if you look at what the county put forth, all my surrounding neighbors are B4 except for the Peterbilt dealership, which is right on Route 45.
Okay.
And I don't know if I answered Stake's question.
Well,
The question really was, I'm sorry. You
Were we
ahead.
going to go both locations? No. We will not do a location
that
in
be-
city of Urbana. We
that-
are doing it outside of the city of Urbana now.
can we be assured of that by changing what your
Well-
place is then?
Well, the thing is, I doubt whether anybody is going to spend $1 million on another facility like we're building. So I'm not going to open up another facility because that would be contradictory. It would be silly for me to open up two facilities. And I don't think anybody else will open a facility because, again, as far as a range and a shop, as far as shops go, you guys still have special permits to allow or disallow. And that would have even been for me. We never even got to that step in the phase of actually proposing the building and which building we were going to use, and you still had veto power in special permit, as I understand it, and so did the council. So,
Okay, but that wouldn't be for sure, because if it's there, sometimes somebody's going to use it.
well, and I believe that you have the right then to say under a special permit, you could deny a special permit and not allow them to open a shop or a range in the city of Urbana. And actually, I would rather that you not allow them because for competition purpose, I would rather have no other shops and no other ranges. But that's just me, and I don't think you'll do that for me because that would be not fair to other business owners.
I think we need to keep in mind here, we're making a zoning decision. That
Yeah.
we're not even making a zoning decision. We're deciding whether to protest a zoning decision by another jurisdiction. So what becomes possible are all the things that are possible under this changed county zoning designation. And the gun shop regulations of the county will apply to this shop in the moment. As I recall from our recent discussions, in any zoning district in Urbana now, a gun shop, as distinct from a general sporting goods store, is a special use. And we've never approved, as just pointed out, a special use gun shop yet in the city of Urbana. So there is no approved one that we have to worry about, if that's what we're worried about.
No, and if
And
the-
and that's not the subject of this
No, it's
anyway. It's a
not.
zoning
Is
case.
this the highest and best uses? We can determine it based on what the county is requesting.
Right,
to be
right.
protested or
And
not.
I would modify that just slightly. It's the highest and best uses. We are not focused on a single use. We are focused on a category of uses based on a zoning
Now, in the
category.
event that this were ever annexed, there would be an annexation agreement, and if the zoning was changed to make it compatible with city zoning, there would be a special use permit process. I assume that would be as a part of that when that came into the city. So it's something to
assume.
tuck away in the back. We had
Correct.
talked about a lot of issues that folks were concerned about
Right.
in terms of the building of this, so. Any other questions for the petitioner?
To give you also an update, the zoning board of appeals approved it unanimously at the last meeting, and I just left actually the environmental land usage committee, who then it was seeing, and it was a 6-1 vote. One person actually opposed because they would have liked to seen the process that you all put in place as far as putting the actual texting into the amendment. But other than that, everybody else approved it unanimously and thought it was good use of the property and thought it was an addition for revenue and all those things.
Okay.
So,
Anything else you want to throw in?
I don't think so unless you have specific questions for me. Otherwise, I will.
I think we're out of specific questions. Thank
Okay.
you.
Thank you.
Anybody else want to address the Plan Commission on this case? If not, are there any further questions for Mr. Engstrom? And if not, then let's open it for discussion and motions.
Gonna be a habit here.
You got to give Mr. Fitch back.
Okay, I move that we recommend to council to defeat a resolution of protest on County CZ-ZBA 741 AM 13.
And that's a motion by Mr. Hopkins. Do we have a second? Second by Mr. Fell. Any discussion on the motion? The motion is to defeat a resolution of protest, i.e., it's okay. And that's a recommendation that goes to the city council. If there's no further discussion, could we have a roll call, please?
Mr. Hopkins?
Yes.
Mr. Otto?
Yes.
Mr. Pollak?
Yes.
Ms. Stake?
No.
Mr. Ash? And Mr. Fell?
And that motion passes, and that will go to also the 20th,
Yes, sir.
the May 20th city council meeting. Okay, last, we have another Champaign County ZBA case, 743 AT 13. Request by the county zoning administrator to amend sections of the zoning ordinance regarding rural water district treatment facilities.
All right. As you noted at the top of the meeting, I did hand out a copy of the memo on this. It's something that you already had in your packet, but it was a little confusingly ordered. So this is the latest language that the county is proposing for that paragraph 13.2.1.a.4.a. So it's a little different than what was discussed in the memo. We'll get to that. So really the purpose of this proposed amendment is to revise that section to authorize approval, to give the county board authorization to approve a variance, special use permit, or zoning use permit, despite the fact that a development may violate subdivision regulations of a municipality in which which has jurisdiction over that development. And there are very limited circumstances under which this is proposing to be allowed. They're proposing it only in the case if a requirement for annexation agreement is a requirement for plat approval by that municipality. Also only if it involves expansion or construction of a water treatment plant or related facilities, and if those facilities are owned by a rural water district, and also if it's operated by a predominantly rural water district, and only when the municipality has its own water treatment plant and related facilities. So those are the four things they're looking at. The other two parts of this text amendment are basically to allow implementation of that main theme. Revise section 9.1.9 to authorize the county board to approve variances per section 13, and to require 3/4 of the county board to approve a variance when there's a written protest against said variance submitted by a township within 30 days of the ZBA or county ZBA hearing. And the last part is to revise section 9.2.2 to require 3/4 of all members of the county board to approve the text amendment or a map amendment when a written protest against that amendment is subjected by a township within 30 days of their county ZBA hearing. So to explain this case a little more, currently section 13.2.1 of the county zoning ordinance explicitly prohibits the county board from approving variances, special use permits, or zoning use permits when the proposed use or construction would violate subdivision regulations of a municipality where the lot is within the jurisdiction of that municipality, and when that municipality has enacted subdivision regulations.
So that means we're not talking the ETJ, we're talking within city limits.
Oh, no, this is within the ETJ.
The ETJ, okay.
Yes, by state law, cities regulate subdivision, or they have subdivision authority or jurisdiction within the entire 1.5 mile ETJ. So the proposed amendment would add an exception to that explicit prohibition, which would say the county board could in fact grant an approval for a development that does violate a city's subdivision ordinance, but only under those specific criteria that we discussed. And really those criteria are crafted so that this ordinance would only apply to one property or one situation within the whole county, which is the Sangamon Valley Public Water District. They're proposing to build a new treatment facility outside of Mahomet, and that would require the county to approve a zoning use permit, which currently they cannot issue if Mahomet says that the development does not comply with their subdivision ordinance. And there's some people from Sangamon Valley who will speak to that situation a little more thoroughly, perhaps, after my presentation. So issues and discussions. As I mentioned, the city has subdivision and land development jurisdiction over the ETJ. The county holds zoning jurisdiction. So it's important that these two be in harmony and that one doesn't cancel the other out. So in this case, the proposed amendment as it's written really has no direct effect on development within Urbana's ETJ, since we don't have a rural water district in our ETJ. However, there's some larger implications here. If Champaign County grants itself authority to approve developments in conflict with the city's subdivision ordinance, that could be troublesome. It would set a precedent that the city would not appreciate, and it would go against our ordinances and against state law in terms of home rule and Plat Act. So looking at our comprehensive plan goals and objectives, Goal 21, identify and address issues created by overlapping jurisdictions in the ETJ. As it's currently written, the text amendment would not be consistent with that. In terms of zoning impacts, again, no direct impact for us, but there's implications that could allow to future zoning impacts. Having explained all that, we just heard tonight that the county, they were proposing to approve, the county Environmental Land Use Committee was going to hear this case tonight, but they forwarded it to their June meeting. So at this point, staff is recommending that Plan Commission forward this to the next Plan Commission, or possibly the one after that, in order to give staff time to work with the county on some language and see if we can find something that might be a little more palatable to us legally.
And I would just add that we've learned a little bit more about the situation. We're hopeful that in working with Champaign County staff and potentially City of Champaign staff that we might be able to craft the text amendment so it can resolve the current situation with the water treatment plant, but does not open up some of the broader implications that we're concerned with. In particular, we would look for linking this text amendment to public health, safety, and welfare, should there be a need for the water treatment for residents of Champaign County. We would look to limit the exception much more than is currently proposed, perhaps just to the zoning use permit, and we would look to remove some of the language that deals with granting variances or explicitly allowing violations of a municipality's subdivision regulations. This will give us a few weeks to work on this and see if there couldn't be a text amendment that the staff would feel comfortable not recommending protest. It's uncertain at this time, but we feel that this would help to sync this as well. We don't take protests of the county's text amendments nor map amendments lightly. We do seek to offer alternatives, protests that would be conditional upon a rewording is an approach that we've used successfully in the past.
As this is currently written, the staff recommendation is in fact a protest.
Yes, but more explicitly, we're asking for a continuance so that we might have an
No, I understand.
alternative to
As long as we presented
present.
it and we're going to
Absolutely.
cover that, right now you guys are opposed to it as it's currently written. Okay. Questions for staff?
What happens to a request like this if we protest it and Champaign doesn't? Does it automatically get defeated?
Yes, if any municipality in the county protests, that kicks in the requirements for a 3/4 supermajority for the amendment to pass county board.
Let me follow up on that. If this were going to be voted on tonight and we went ahead and we lodged a protest or any other municipality did within the county, and the county board met and they came up with the requisite 3/4 to pass this, then in fact they overruled the protest and this becomes the law, and the recourse for the city then would be legal in nature, and that would be the only way to prevent. I mean, the city would have recourse if we thought that's interfered with our zoning regulations?
I think we might have to wait until something was approved within our ETJ for us to have standing to challenge it, but yes.
Okay. Any other questions for staff? We have some folks here. Would you,
I've got one.
I'm sorry. Go ahead.
Do we have clarity on the municipality's subdivision jurisdiction in the 1.5 miles is absolute? I guess, in other words, let me put it differently. What I don't understand is all this would do is allow the county to grant a zoning permit. But if the municipality has subdivision jurisdiction, then how would they get a building permit?
So the county doesn't actually have building permits. They just issue these zoning use permits in lieu of that. So the way a development works is the applicant goes to the county for the zoning use permit, and usually the county will look at the property and make sure it's been legally platted. So we often get requests from the county, did you approve this plat? And sometimes we may have not, so that we'd ask them to go ahead and plat it legally. So that's the way the process works in general. Does that help?
Not really,
There's
because,
three things, I'm sorry, there's
Yeah.
three things going on. There's the zoning permission from the county, there's the subdivision approval by Mohammed, and then there's the use of the subdivision approval to force annexation. So Mohammed is requiring annexation as part of their subdivision approval. The folks here to speak tonight do not wish to be forced annexed into Mohammed because they are a separate utility provider, and it would cause difficulties for their mission as a district. So there's a conflict. The conflict really comes in the village's ability to demand annexation as a condition of subdivision. So you see what we've got, four jurisdictions rather, Urbana, Champaign County, Sangamon Valley, Village of Mohammed, and then we've got 3 different types of approvals that are only linked maybe a little bit indirectly. So we would look for subdivisions that meet requirements, that we would not want to not protest a county text amendment that would allow illegal subdivisions. We would still want that assurance, and that's another thing that we would look to craft perhaps better in a revised text amendment.
so Mohammed, to use the specific case, can be forced to not require annexation? I guess what I'm trying to get at is what's the authority in the ETJ of the municipality?
In this case, it's a subdivision approval.
Okay, and so they've got it, and this doesn't change that. The county can't decide to change state law
No.
about that.
No.
So I don't understand the intended mechanism here, how it accomplishes how it solves the problem that's in front of us. And maybe somebody can
The
explain that to
county,
me.
and I think the gentleman can explain it better, as I understand
Okay.
it, the county would be able to issue a zoning use permit where they cannot currently under their own zoning ordinance. They would be able to issue a zoning use permit, which is like our building permit, to allow a water treatment facility that is soon to go out to bid and is necessary to serve the users in the district, which include not just rural Mohammed, but smaller communities that are served. And one thing we would maybe want to look into would be if there are deficiencies in the current water treatment system, that we wouldn't want this jurisdictional dispute way far away from us in Urbana to cause any problems for the public health and safety, necessary for improvements to a water district. But these would be really good questions to ask the experts from the district, and I'm sure that we can get additional information on the specifics of the case that have brought this strange text amendment to us.
Any other questions for staff? I guess that's our cue. With the petition, the folks, these aren't actually the petitioners, are they? It's the county that's petitioning, correct?
Right, they had
Anybody
a meeting.
in the
They had
audience
a
want to
meeting
address the
tonight,
Plan
so.
Commission about this case? If you folks would please sign in for us and let us know who you are.
We did sign it up.
Yeah, that should do.
Do it again?
Do it again, please. If you run a utility, you're used to paperwork.
Yes. While Bud's signing in there, I'll introduce myself. My name's Kerry Gifford, and I am the general manager for the Sangamon Valley Public Water District in Mahomet. And I kind of like to start out, maybe give a little background of our history, how we got to this point. We provide water and wastewater services in the Mahomet area. We've been there since 1966. We serve about 4,800 water customers and about 4,300 sewer customers. In addition to that, we provide services in the other areas of the county to the public water district in Seymour. Excuse me. We do all their billing and their water plant, water system operations and maintenance there. We have also an intergovernmental agreement with the village of Sedoris. We help them with maintaining their water plant and their water system. We feel that we're a very intricate part of the county and a very good asset to keep around. And we are considered a local government, just as the city of Urbana. We just don't tax. We're a user district. How the district got formed is back in the 1960s, and I think Bud might be able to help me out a little bit with that. The north part of Mahomet, the village did not have an interest in serving. So they formed their own public water district and developed Sangamon Valley from there. And it has grown over the years. And through the 90s and early 2000s with the boom, it kind of outgrew the current water treatment plant and storage facilities. Currently, we're at a point with the water treatment facility where we need at least 350,000 gallons of water storage, and we only have 125,000 gallons. The drought of last summer, our plant's rated at 700 gallons per minute. We were hitting our capacity of our water treatment plant at times. So the board's been pretty progressive in planning, and we've had a water project and plan done with the state for a while. So we started moving forward on trying to develop a new water treatment facility right next to our current water plant and developing an air storage tank so we would have adequate supply for safety for fire protection. You want to jump in and help me out here a little bit?
Well, as Kerry mentioned, we've been in existence since 1966, and we really have outgrown our present facility. We have secured already the proper zoning through the county to expand our plant and to maintain and again the fire protection and the quality of water for our customers, our patrons. We need to build this new plant. We have been granted a Illinois EPA loan, a low-interest loan for 20 years to build this facility. We're presently in negotiations with Busey Bank to possibly see if we could get a little better interest rate. So our purpose is to keep our rates as low as we can for our customers, since we're a users district. And as he'd mentioned, we do not tax anybody. We're solvent. We are a government entity. We are a branch of the county. We have 7 trustees that manage or look after the affairs of the district. They all are appointed by the county. And we service an area basically north of Interstate 74 and presently just east of Route 47 where it goes north. Someday we'll probably service the west side of 47 if that area ever gets developed. The village basically has conceded that area to us because they can't service it. And the cost would be prohibitive. And so they chose back in 1965 or 66 not to run water mains out to that area. And we're basically the Lake of the Woods area and so forth. So, but at any rate, we are trying to take care of our patrons, our customers. We want to give them good fire protection. We want to give them a good quality of water. Go ahead.
Now, I kind of want to talk about how we got to this process of this variance. We originally did go to the Village of Mahomet with wanting to work through them with the 1.5 miles. But the holdup with the whole thing was the requirement in their subdivision ordinance to be annexed. We don't feel they have a legal, in our opinion, a legal right to do that, for one, but it's not in the best interest of the district to be annexed into the Village of Mahomet. But we went to them, we tried to negotiate, we went to a public meeting, we requested an intergovernmental agreement be worked out. It died on the floor for a lack of a second. And at the same time, when we were negotiating with the Village of we were going through the county process because of the subdivision requirement of annexation of the village. We wanted to be able to work with someone else potentially. And we had been through the special use permit process. We had to do a zoning change for the property where the water plant was going to be at. That night of the meeting, when they turned down the intergovernmental agreement, the board automatically turned around and voted to protest our zoning change. So we couldn't get anywhere. We didn't have anyone to work with. We went through the protest process, and we did override that 27-0 with strong support from the county. And now we're at the point where the only thing left is a zoning use permit. I won't call it a building permit because it makes more sense to me. We need a building permit to build. But because of the municipal and county agreement and what's in the county ordinance requiring us to meet the 1.5 miles, John Hall thought it'd be best that we had a variance. So the variance was, text amendment's been a moving target. This new one here, we haven't seen the latest adjustment to it. But, and that's fine, and that's the process we want to go through, because we don't feel like we have an option. We have a conflict with 2 water districts in Mahomet. In our opinion, they want our water district. We feel their protest shows that. Excuse me, sorry. So we're back to working with the county. We got word that there could be a potential protest from Urbana and Champaign. We feel we have the support through the county to get the variance completed, but we don't feel it's good practices as a local government entity to not do everything we possibly can to work with the local cities and maybe come up with some kind of creative compromise so we don't create any intergovernmental problems. So that's why we're here, and we met with your staff. A pleasurable meeting, got good people there, and I feel pretty good about maybe being able to find some kind of compromise on all this to help the solution, get a solution to this problem, and to sum it up, to get this problem back out in the western part of the county between us and Mahomet and get everybody else where they don't have to deal with it.
Are you pretty clear on why the way this is presented to us creates a larger question that we need to be concerned about?
Oh, I understand exactly the big picture, sure, and we don't want to create an issue either where there's problems between the county and the cities, and we don't want to be the center of that. We want to be we're a reputable business. We're part of the community, of the local community of governments, and we want to make this work.
Now, also, we had a question, or we wanted to make a statement, is we are not, we are a government entity, but we are not a subdivider. We're not platting any lots. And so we question the validity of saying that we have to fall under the Plat Act. Because we already own our property. We have it, we free and clear, we own it. And we're not subdividing anything, we're not taking a larger parcel of ground, chopping off a piece, and doing anything like that. We already own our land. And so we're not going through through the development process.
It'd be really nice to be able to settle this without having to ask a lawyer their opinion about that particular issue.
Yeah, I can agree with that.
Are there any questions for these gentlemen from the Planning Commission?
So following up on what you just said, in the subdivision ordinance, and I don't know Mohammed's, generally includes things other than the actual subdivision of land, that it has requirements about street access and rights of way and utilities and so on. But for the subdivision ordinance to apply, there's got to be some aspect of it that is being applied. So what aspect, given that it's not the platting of a subdivided lot, is Mohammed claiming that they have jurisdiction over what you do?
Well, the initial conversations with Bob Martin over there was they were not concerned with what we were going to do out there at the water plant as far as roads and sidewalks. Their only primary concern was that we were annexed into the village of Mohammed. So we've never had that conversation with the village. It was just ended because we couldn't come to agreements on annexation.
Okay, and annexation is about annexing the parcel on which your facility stands? It has nothing to do with your service area?
It's the parcel of our property.
Yeah.
But we have legal concerns with that.
Yeah.
But having said the service area, we do service a considerable area that is already annexed into the village. And so we're servicing some of their patrons. And they're trying to give us heartburn by denying us the privilege to give them fire protection and quality water. Now, doesn't that make a lot of sense?
Sounds like government to me.
Yeah. See, so Mohammed's been on an aggressive annexation program. The bottom line, the reason that we don't want to annex is we know what their designs are. The village of Mohammed is financially strapped. They're building a new sewer plant that's remote from ours that was supposed to come in at about $13 million. To date, they've spent over $17 million on it, on overruns. They're looking for, they would like to take us over, is what they'd like to do. And they'd like to have our customers for a base to get more revenue. That's the bottom line. That's what they're looking for. It would not be fair to our patrons where we're a user's district. Our patrons only pay for what they use, what goes through their meter for their water and sewer, to be taken on an obligation in the village that they have no jurisdiction over or no say-so about.
Any other questions?
Nope.
It's politics and money.
Anybody else in the audience want to address the Plan Commission on this?
Better talk a little louder, maybe she does.
You folks have anything you want to add?
No, I just look forward to working with your staff. I'm hoping we can find solutions so we don't cause any problems for you folks with
Well,
the
if
accounting.
if there's a solution out there, these are the folks who will be able to
Yeah,
find it
I
for you.
agree with that.
And we don't, we don't need any more protest. Even though we overrode the last one, as Kerry mentioned, 27-0. And that was when the county board had 27 members. Now they're down to 22 members. So we had pretty good case, and it just made common sense for us to move forward and provide a quality service for our customers.
Very good. Thank you.
All right, thank you.
Thank you.
The request here is to give these folks some time to work and see what they can do with this thing. And so if there is no objection, let's forward this to the next meeting at which we have some staff input. Ms. Ratto? Unless you guys want to talk about it, it's okay with me.
I would like to talk about it a bit because I don't know when the next meeting will be, and by chance, might not be able to attend.
Fire away, perhaps there are some things that our staff can convey to the county as well as the folks from this utility that might be helpful, so.
The particulars of this, my comments aren't directed towards the particulars. I don't know anybody involved in this and so on. But in general, I think that there's a good reason why municipalities have the right to annex and to some degree control their growth. And so when you have an entity that can provide essentially primary basic city utilities and add to the population base, but is free from actually being a part of the city, I think that creates problems. And we've got problems here because we've got unincorporated areas around. We've got Savoy, which didn't used to be anything and is now incorporated in as a player. I think we have too many government entities. And so they need to work that out. I think the zoning principle that's in place is a sound principle, and I would be concerned about trying to circumvent that. And if the county board believes strongly enough in their case, they can go supermajority.
Mm-hmm.
But I think that as a matter of principle, I wouldn't want to fine-tune the county's, go along with fine-tuning the county zoning that's directed at resolving a dispute that they need to work out there so that their government entities and so on. The people out there are going to get water, they're going to get sewer. What's the most efficient way to do that? I don't know, but there's a good reason for the current ordinance. And I'm a little concerned about the county doing anything other than the supermajority. If they believe strongly enough in the case, supermajority. So I would discourage you from crafting language.
They may have to do a supermajority. In any case, one thing that would benefit Urbana is if the language were less objectionable, and that would be a goal to work towards.
The language. So why couldn't they, under the current zoning language, simply through a supermajority grant the water district the right to build without tinkering with zoning language, which is actually targeted to resolving one case, rather than zoning language should be a set of principles whereby we operate?
Evidently, they feel they need to amend their ordinance to grant the permit. My point was, this may require a supermajority in any case. So wouldn't Urbana be better off with language that's more specific and less objectionable?
I think the answer is yes. And I'm concerned about this having nothing to do with Muhammad or this company or these gentlemen or any of this stuff, having the county take the authority and limit our control over our own extraterritorial jurisdiction. And if there's something that can be worked out that eliminates that from this formula, then I think that's a good thing for everybody involved. And if we can't, and they decide through supermajority to do it anyway, I would encourage the city of Urbana to look for recourse. Because this doesn't affect us directly, but it could very easily in the future and in a very negative way. So I think that your approach to this is exactly right on the money. Try and limit what's happening here in terms of its effect on our zoning ordinance and the future of what happens in our city, and allow this to be worked out through the parties that are directly involved in this.
So, for my own benefit, I want to sort of lay out what I understand the game here to be. Muhammad's going to protest in any case. So there's going to be a supermajority required. So our role in that probably doesn't make any difference. all right? The county is doing this, proposing this text amendment, so that they can change their rules so they don't break their own rules. All right, that is, they can't do this under their own rules now, so they're going to change their own rules so they can do it. And both the change in the rules and the actual action under their new rules will be protested by Mohammed, subject to whatever other negotiations in this specific case happen to occur. And to me, that sort of means that we are non-players in those portions of the game. Those portions of that game are going to be played out regardless of what we do. So as I understand what we're trying to do is, if we can influence the change in the county's rules that the county makes so it can break its current rules in a way that's less problematic for us in future contexts and in the general principles which Danny's been raising, then that's what we can influence, maybe, and that's maybe potentially worth influencing. Is that?
That's a pretty fair summary.
Sounds
Yeah,
like
okay.
insurance, essentially. Sounds like insurance, I'd then presume. We're
If you
protecting
can-
ourselves on the
If you can
front
steer the
end.
discussion
Right,
to make
right.
it better, less possibility that there will be a downside to us later on, then that's a worthwhile thing to do.
Yeah.
That's kind of how I look at it.
I kind of a follow-up, though, but isn't it staff's position that allowing the county any sort of authority to change zoning is not good for the city, and doing anything like this sets a precedent that we don't want to set? So don't we really want to say, we're not going to agree with any language you put in there to do this? No matter what you put in there, we're not going to agree to it because it's going to set some kind of precedent. So right now, it's a water treatment plant, and next time, it's something else that they want to put on the fringe of Urbana.
Yes, that's
So
true.
don't we, isn't it really our position that we don't care what you say, don't say anything, because we're not going to agree with it?
I think
So-
the bottom line
so
is
why
if
are
you
we
assume,
giving- why are we going-
that there's going to be a supermajority vote that's
Right.
going to,
But
whatever
why are we bothering as a city to go back to the county and say, change your language to this that's more appropriate for what we feel it should be, when we don't think it should be there at all?
That doesn't mean we won't protest it at the time. It means that what they come back and do anyway will have less dangerous implications for Urbana, and that's probably worth doing.
But I think anything they come back with in this light has dangerous implications for
Then we-
Urbana, so why are we spending our city
Then
time?
maybe we protest as well. It doesn't matter if we protest or not.
So play out the rest of the game. We get better language, still language we don't like, and we still protest that language. But that protest still makes no difference.
Because
That is
Mohammed
in
will
the game,
protest.
because Mohammed's going to protest anyway. So as I see it, our only opportunity to make it less bad is to try to influence the language that the county actually puts up for approval. Because that's not a decision or just a situation we can affect.
And I think actually
In
that's a good point.
any other way I can come up with.
As you
Plus-
talk to the county about, and these folks about these kinds of possible solutions to this, it should be very clear that if they can adjust this in a way that we consider beneficial to us, that in no way guarantees that we're not going to protest anyway.
Yeah, I think I see that. A couple of things. I don't think that we can safely assume there will be a protest. It may be likely. There's Mohammed, as you mentioned, and Champaign, but I don't think we know that for certain. And I think we do care what the language is ultimately, and if we can influence improved language, that's really beneficial. I've been working on drafting to limit or change the approach so that it really has far fewer implications for us. I can share my latest draft, but that's really all it is, and there's more to be done. But I mean, you can take this home and look at it, and you can see that it's there's a way to get at the problem without opening it up quite as much as is proposed.
I encourage that discussion. I think that's beneficial.
It seems to me also that, I mean, another opportunity we may have, though I don't know exactly how, is to influence the opportunities for intergovernmental agreements. Because it sounds to me that that's the way this should be resolved, not by trying to make a specific case work by fiddling text in a zoning ordinance. It's basically an intergovernmental dispute resolution problem.
I think the timing's an issue. I think this has dragged on for a while, and now the funding's been provided and the project is at hand. So I think that's what brought it to this point for the county.
Any other questions for staff?
Yeah, I mean, I guess if the shoe's on the other foot, I mean, if we were in a similar position, how would we feel if Champaign came in and essentially took the side of one party to try to circumvent our concerns?
You know, I think that's an excellent question. There's Mohammed's concerns, there's the rural district's concerns, there's Champaign County's concerns. So it's not necessarily Mohammed and Urbana, but I think that's something we really do need to consider.
Other questions or comments? If not, we will go ahead and forward this to the next meeting at which we have information and recommendations available from our staff, pending their discussions. Pardon me? Does anybody in the audience want to address the Plan Commission?
We're looking forward to working with your staff if we can be of any assistance in getting resolved.
Do we have a staff report this evening?
Just a quick note, Plan Commission, you want to add some direction to work on what was it? Your rules.
Bylaws.
Bylaws, that's it. So our manager, Robert Myers, is working on some updated bylaws and he'll brief you at the next meeting.
Okay, very good. If that's it, we don't have a study session this evening. We're adjourned.